All right, everybody. Welcome back. We're going to have a conversation about double patenting here. Well, Sherry's on the panel, so you all know what she thinks about double patenting. And so this is going to be a critical view of double patenting. At least 1/4 of it's going to be critical view. I think everybody has some questions about it. I know Vince has a lot to say about it as well. Looking forward to this. I do have a little bit to say about this because I've had long conversations with people at the patent office about double patenting. And, well, I won't say any more than that until the appropriate time. But what we have in store here is a robust conversation in re selects the constitutionality of double patenting, PTA, PTE, and the like. What I'll introduce the panel from, again, starting from your left, audience left to right. We have Doreen Tredillo, and she is a partner at VLP Law Group. Thank you for being here. We have Rob Saar, and he is a shareholder in the biotechnology practice group at Wolf Greenfield. And this is his second time here. You were here last year, and thank you for coming back. We have Sherry Knowles, who we introduced you on day one, but she is a principal at Knowles Intellectual Property Strategies, and she is a member of the IPWatchdog Hall of Fame, and she has been on all kinds of lists. She was former Chief Patent Counsel and Vice President of Intellectual Property at GlaxoSmithKline. And last but certainly not least is Vince Shear, and he is a partner at Haynes and Boone. We introduced him to you earlier today as well. So let's get started, and I guess probably the best way to get started is sort of the way we've done it with the other panels, which is to ask for your preliminary thoughts on the matter. And let me kick it to you first, Sherry. When you're hearing the topic double patenting, in re selects, PTA, PTE, what is the first thought that you want to share with the audience?
Well, that's a great lead-in, Gene. We heard yesterday from Brad Watts that if you want to have somebody believe something, say it a lot of times. So what you're going to hear me say a lot of times over the next hour is that the non-statutory judicially created doctrine of obviousness type double patenting is unconstitutional. And so I think if I can say it 5 or 6 times in this section, in this panel, maybe you will all walk away believing it. Okay, and in fact, it's the middle of the day. Why is everybody so quiet? You know, nobody's asking questions. We haven't seen a robust discussion. I think everybody should repeat my statement after me. Okay, I think you should stand up and say. Go ahead, stand up and say the non-statutory judicial. Go ahead, stand up. Okay. Let's hear it. And meanwhile, you can do a little Chinese exercise if you want, and then. Okay, are you ready? Are you ready? Okay, the non-statutory, judicially created doctrine of obviousness type double patenting is unconstitutional. Give yourself a hand. Okay, we're going to say that a number of times because I'm going to have to get in touch with Brad Watts and tell him whether this works. If you all walk out and say, oh, tonight I'm just dreaming that the non-statutory...
You've just given Gene his...
I've already said it now 4 times. I'm up to 4 times.
This is going to be Gene's pledge. This is going to be at the beginning.
Okay, Tony, count how many times I say it during... Okay, so we know that.
So there will be a quiz later, and you will have to...
You're going to have to decide. Okay, great. Take yourself back to June 8th, 2022, okay? Then there was a letter that came from certain congressmen, Leahy, Blumenthal, Klobuchar, and others, and they had a question. And that was a question, I guess, for the PTO, and it was whether elimination of terminal disclaimers that allow patents that are obvious variants of each other would increase patent quality, and whether patents that are tied by a terminal disclaimer should be considered an omission of obviousness and should stand or fall together. Okay, that came from a bunch of senators in 2022. Okay, so of course that got our attention. And so by September of 2022. I posted an article along with Tony Prosser, who's in the audience here, that says, let's do something about the unauthorized doctrine of non-statutory judicially created obviousness type double patenting. Okay, this is an IP watchdog. If you ever want something published quickly, send it to Gene, and then it gets out. Okay, so what do? If something is messed up as double patenting, the only thing you can do is really go back to the basics. Okay, you really have to figure out, how in the world did we get here? How did we get to a system where a law that's not even a law is taking off patent term from a complex myriad of patents, in particular biotech patents? So what we did was we took the time, and by the way, that is a sacrifice to take the time because we're all on billable hours. We took the time to go all the way back to figure out what was the genesis of obviousness type double patenting and how in the world did we get here. Okay, and that's what we put in that article. That's what I'm going to walk through right now. So basically, you had, of course, the 1952 Patent Act. Okay, so in 1952, we get a Patent Act, which is Section 253A. A patentee, can disclaim any complete claim, but then you get 253B, which is the one that's at issue. Any patentee or applicant may disclaim or dedicate to the public the entire term or any terminal part of a patent. Okay, so there it is, 1952. Now, there's no legislative history on that. There's no interpretation of that. Federico, who was involved in the advisory committee for the 1952 Patent Act, basically had the following to say about that. He said, no specific reason for this provision appears in the printed record, but proponents, meaning people who like that provision, say it may be effective in some instances in combating the defense of double patenting to permit the patentee to cut back the term of a later issued patent so as to expire on the same time as the earlier issued patent. So basically, Congress said nothing when it enacted that in the 1952 Patent Act. There's no legislative history. There's no purpose of it. There's no tying it to a terminal disclaimer to get over obviousness type double patenting. So then the next thing that happens is not until 1961, okay? And in 1961, the MPEP comes out and says you cannot use a disclaimer to get over double patenting. It says the mere filing of a terminal disclaimer does not ipso facto overcome a rejection on the ground of double patenting. So after the 1952 Patent Act was passed, the Patent Office in its MPEP was saying, no, you cannot use a terminal disclaimer to get over double patenting. Okay, that MPEP section continued up through 1967. In 1967, they changed the MPEP, and it said when a patent is involved, a rejection on the ground of double patenting may be overcome only if the claims do not overlap. Do not overlap. So, reading the 1952 Patent Act, the U.S. Patent Office was interpreting that statute to say that you cannot file a terminal disclaimer to get over obviousness type double patenting. And then they changed it in 1967 to say, well, maybe you can use a terminal disclaimer, but only if the claims do not overlap. So what does that tell you? It tells you that there was no clear statutory basis for it and that the Patent Office considered the opposite. Okay. The first case that we had, judicial case, to discuss it was In re Robeson, which was in 1964. 1964, 12 years after the 1952 Patent Act. Okay, In re Robeson, basically, in re Robeson, there were two patents that were at issue. One was filed 2 years after the other. They didn't claim priority to each other. One was to make trimethyl propane, and one was to make trimethyl butane. So one of them started with butyraldehyde, and the other one started with propionaldehyde. So that was the only difference. It's like one carbon, but they had different starting materials to make a certain industrial product. Well, the inventors didn't even want to deal with the issue of overlap or double patenting or obviousness or something. And so they just submitted a terminal disclaimer. So it went to the CCPA, and the CCPA said whether a terminal disclaimer can overcome double patenting rejection has been the subject of discussion. So what does that mean? It just proves it's not statutory. Congress never created this law. Thus, of course, the non-statutory judicially created doctrine of obviousness type double patenting. So CCPA, 12 years after the 1952 Patent Act, said there's been much discussion about what this means and how we should be using it. Okay, and so they had in Ray Robeson basically said that allowed them to use the terminal disclaimer to get over obviousness type double patenting. Okay, so that was in 1964. Then the USPTO added 37 CFR 1.321C after the Robeson case to authorize terminal disclaimers to overcome a rejection of double patenting. That's 12 years after the 1952 Act, and after there's been repeated dicta saying, we don't know what this means or how to use it, and Congress didn't give us any reason for this law. Okay, so there was no congressional rulemaking on it. And we think that this is a non-existent delegation of authority from the CCPA, right? It's a delegation, you can consider it a delegation of authority from the judicial system, the CCPA, okay, to the Patent Office, saying it's okay to take double terminal disclaimers to overcome double patenting. 1964, okay. Now, they could have easily said, what could they have said in Robeson? They could have easily said that the second patent that Robeson filed, he was free to file. They didn't need a terminal disclaimer because the first one hadn't published yet. And back then, they don't publish till they issue. So that was still trade secret information. So he was the only one who had that trade secret information at the time. And he could have relied on that trade secret information to file a second patent application for a different process using a different starting material to make a different organic compound. And that should have been his right to use his trade secret information until it's published. Okay. But instead, the court decided to go ahead and then create this doctrine. Okay. So that's basically where it came from, and then it just grew from there. And then we go, all the way up to the other cases, and we're going to talk about, Novartis versus Ezra, leading up to In Re Select. So basically, we've proven that it's non-statutory. There's no legislative history. It was in the statute. Okay. The Patent Office initially, after the 1952 Patent Act, said you can't use a terminal disclaimer to get over it. And then this case came out and said, we have no idea how to use it, but it's kind of a good idea, so let's do it. And from that little seed has come this entire morass that we're dealing with now with all the complexity of terminal disclaimers and double patenting.
Okay, great. Thanks a lot, Sherry. Vince, I'll just sort of open to you to talk about or bitch about double patenting, however you want to describe it.
Yeah. It's as we'll explore on this panel. It's become sort of a complicated issue, and in a lot of ways, it's overly complicated. And I think the reason for it is the URAA. Right? The doctrine, when it was originally created, made a lot more sense in a 17-year world. Right? When we moved to the 20-year world, we took away a lot of the teeth to it. So we can go back to cases like Fallow, which even acknowledged that there was that although it's a diminished impact, there's still some potential gamesmanship. And so when we look at the original doctrine and the origin of it, and we look at reference that was made here to cases like Gilead, it was gamesmanship. That's what we really think about when we're looking at double patenting. Are we playing games to get the buzzword of unjust time-wise extension? Right? That's what the doctrine was supposed to avoid. But we have this problem with 321 where we talk about now suddenly we have these two policy justifications where the Patent Office, for convenience, push together and say, well, let's have a single instrument for disclaimer. Well, why? And why does that still hold water today? Like a lot of these cases that we still see coming out, we see the Patent Office routinely saying, yeah, but what about the second policy reason? Avoiding multiple suits. Well, why can't we split those up? Well, we can't because the Patent Office says so. They say it has to be in a 321 single disclaimer. Well, is that fair? Well, now in this world with PTA, well, you're tying my term on the basis of common ownership. So that's a problem. We also have other issues where you made reference, and we'll talk about Ezra, so I won't really jump down that one too much. But we have these statutory scheme changes, and how do we now look at unjust enrichment, and was it properly decided in Select, and is there really statutory authority or a clear statutory language for the Federal Circuit to properly have decided that case in the way it did? I contend that there isn't, and that they got it wrong, but that's where I'll leave it for now.
Okay, so Rob, how about your initial thoughts?
So I would love for obviousness type double patenting to be declared unconstitutional. I'd be the first one to celebrate.
That's number 5. Number 5.
I need to
We need
have
a counter.
a counter.
Yeah.
I'll effort that.
Thank you.
So I would love that. My personal turmoil doesn't go back that far. It's to 2014 with Gilead. And prior to Gilead in 2014, double patenting was primarily a problem for subsequent patents, downstream patents. But what happened in Gilead is it shifted a direction of the current. It introduced a new direction where now patents that are vulnerable are existing patents, right? So now it can go towards subsequent patents, existing patents. That created a whirlpool, and good patents are drowning. And the law has not tossed us a lifesaver, right? The law is primarily based on pre-GATT decisions, and it's not helpful to us when we want to remedy a problem. There is no judicially blessed path forward for us to do it, absent a terminal disclaimer that sometimes isn't available.
Doreen, I'm trying to effort a counter here. But
That's fine.
Go ahead.
Yes, as Rob touched on, Gilead kind of opened the Pandora's box, in my view, as well, because up until Gilead, the concern was with the pre-GATT patents, it's 17 years from grant. So if you didn't file your patents in the same family, or you could game them, because you can, by stacking the filing dates, you end up with a later expiration date. But after GATT, that was all but eliminated, except, of course, for patent term adjustment, which I think what we see in the In Re Select case is how complicated this all becomes when you have a bunch of patents in the same family and patent term adjustment. But as Rob said, with Gilead, it became, well, we're going to apply this post-GATT. They were both post-GATT. And I thought Rader's dissent in Gilead was great, because he focused on the fact that prior to GATT, you could file continuations after continuation ad nauseum. And so you don't have that problem anymore. And as Rader also observed, you didn't have the problem of more than one assignee suing in Gilead because they were co-owned. So it just has taken on a life of its own, and I may get to talk about an ODP nightmare I had several years ago, and how it ended up. And it's just been impossible to deal with. So yeah. I'm a second vote for.
Yeah, I will just say that ODP should be unconstitutional. I think it's the right and privilege of everyone on this. I think part of the Gilead sort of, I think of it as there really was a duo that kind of came out at the same time. right? Gilead kind of set up this almost they cherry picked a situation that kind of exposed a potential gamesmanship issue, and when it was separate families, and then to kind of reinforce their notion, like, see, this is still a problem, they pulled AbbVie v. Kennedy. Right? It was, I think, even on the same day, and they said, see, to make explicit what we were already saying in Gilead, here you go, and they illustrated a problem where in Kennedy, they intentionally made some decisions to drop their priority chain, right, so that they engineered a later expiration date. Right, so it was almost a disingenuous justification of their decision in Gilead to kind of push this ball further down the road to say, see, this is a problem that needs to be addressed.
Yeah, we're talking in, I guess, 2 panels before about expert witness creep and about things going further and further. Well, that same thing goes on with doctrine of obviousness type double patenting, because there are no guardrails, because there's no statute, so it just goes where it goes. And I think most people in this room have gotten office actions where you've gotten 12 to 15 obviousness type double patenting rejections. When the examiner's just mad and they can't find prior art, they'll just stack up any number of obviousness type double patenting rejections. And then after they do that, they'll combine your patent with third-party prior art. Where is that? Where is that in the statute? It doesn't exist. That is also unconstitutional. So it's either, patents with patents that you can't assert for double patenting, or it's third-party prior art, okay? I don't know if anyone has experiences on this or not, but why are we all just sitting back and just taking this? I think probably all of us have gotten rejections over our other cases in light of third-party prior art. Where's the law that's based on, And then you have clients, and the clients don't want you to stand up on your soapbox to argue that on their dime, right, and with their patent applications. So where do you go with it? I think we have to go with an industry on that. We have to go with a group approach, and be speaking with one voice and saying, no, that's gone too far, and it's because you have no guardrails, and it's because it's non-statutory.
Yeah, and to add on to that, it almost got worse. Well, it did get worse in the latest revision of the MPEP, right? Because now they're saying with double patenting, you have no choice but to address this head on right at the first instance it's raised, right? So you now have to amend or disclaim. So we used to all the time tell people, hey, let's request for it to be held in abeyance. Let's punt this down the line because it's just premature. There's no reason for us to be addressing this, especially when it's not statutory and unconstitutional. But now in the MPEP, they're telling you, and they're telling their examiners, no, if that's the case, hold that as a non-responsive response and kick that back to them. They have to address it. So there's no statutory authority. It's a completely fictitious doctrine. It's something that it's subjective, right? And ultimately now it's a determination at the examiner level who's saying, no, you need to make this, file this legal instrument or make some kind of argument to create this record to what your invention is and it isn't, or you need to make amendments and separate these claims. But where's this coming from? What authority?
How did we get here?
Yeah, I just told you how we got here, Gene.
No, I know, but I mean, I understand what you said. Sort of, because the patent office position doesn't, to me, make an awful lot of sense. Because they'll say that, obviously, I've been told, not by anybody who's currently there, but previously over the years, I've been told by people that obviousness type double patenting has nothing to do with obviousness. And I'm like, well, then that makes no sense whatsoever. I mean, because that's the whole justification for having this, right? Is that they had to create a doctrine to prevent you all from getting patents that you otherwise would be entitled to. And the way to do that is to stretch and to pull and bastardize what it means to be obvious. Yeah. Right? So if it doesn't have anything to do with obvious, I mean, maybe that is actually the truth. It doesn't have anything to do with obviousness because obviousness is statutory.
Sure. And what do you bet that, they're having these new committees between the U.S. Patent Office and the FDA about how to rein in, the bad, ugly pharmaceutical patents. And what do you bet they're not saying? Terminal disclaimers, obviousness type double patenting. Just start using that. Just start, cutting the lawn.
Let
Just
me
start,
ask you this, because you fought this battle back in 2007, 2008. So much of what we're dealing with right now seems like they're trying to relitigate how many claims you can get and how many continuations you can file.
Right.
And they were told that, well, you can't do that unless Congress amends the statute. So they're just increasingly coming up with different ways to narrow claims. Of course, when you got to narrow this, you don't have enough disclosure because it's too broad, narrow. And then on the other side, the FDA and the Patent Office, to some extent, mostly the FDA and the rest of the government, doesn't want you to get any more patents. This is bad. This is evergreening. It's, never mind the additional innovation that goes into these things. And on day one, we talked about this. It's funny that it's just evergreening it bad, and there's nothing new and innovative there. But you give 100 people the choice. Well, do you want the latest drug, or do you want the one with the side effects? Everybody's going to say, no, give me the latest one. But there's nothing innovative there. Why would you want the latest one compared to the one that makes you vomit after you take it?
Yeah. And it's interesting you say that obviousnness doesn't really have anything to do with it anymore. Sometimes examiners now are taking very early patents, not even in the chain, but earlier families within some group of technology. And that might be a broad claim, and you have an unobvious improvement, but that unobvious improvement might overlap a patent that was filed 15 years ago. And they're giving obviousness type double patenting on that, even though it's a non-obvious improvement. Now, sometimes you can get over that with good arguments. It depends who your examiner is, but sometimes you can't. And when you can't, you've just made that a pretty worthless
So we
filing.
talked about the creeping boundaries of a doctrine unmoored by statute, and I think Doreen has a good example of that.
Yes, mine is not related to Cellect. It's related to a single common inventor and allowing the Patent Office to reject your claims over another application that doesn't share common ownership and doesn't share common inventive entity. It just shares a single common inventor. And I had a case a while back. The client developed an antibody to a particular target. They developed jointly with another organization the antibody drug conjugate. So the other organization had the patents covering the antibody plus drug. My client's patents covered the antibody. They cleverly thought if they filed the U.S. patent on the same day, they would avoid them being prior art against each other. But they had one inventor that was listed on both. No common ownership. Now, prior to the publication of applications, they couldn't have levied this rejection because it would have been in secret. They couldn't have said, okay, we're going to reject your application over this one. But now they could because they're published. So what they did was they rejected my client's antibody application over the other party's antibody drug conjugate for obviousness type double patenting. And at the time, and this was something that creeped up from the MPEP that we mentioned, because we did a whole survey of the history. I said, we're going to appeal this. This is not right. This is the MPEP doing this. We looked, the MPEP started this back in 1988, discussing that you could reject claims for a single common inventor. But we surveyed the case law and no cases had done it. So we confidently filed an appeal brief, and then In re Hubble came down. And In re Hubble, the Federal Circuit, said, we adopt what the Patent Office says, and we are going to apply it with a single common inventor. So therefore, we could not get claims to the antibody, which was the novel part of the antibody drug conjugate binding the target, because of obviousness type double patenting. And it was something that was created in the MPEP, carried through for years. And In re Fallot, if I'm pronouncing that correctly. There was a footnote in which the court said, look, nobody raised the fact that there's no common ownership here. There's only a single common inventor in common. And I know the MPEP says that, but we don't hereby sanction what the MPEP says. Well, the court in Ray Hubble did. And I was saying to Rob, I was surprised when I looked back and it was Judge O'Malley who actually authored the decision in Ray Hubble. And Judge Newman authored a very vigorous dissent. So that's my ODP nightmare horror story.
Yeah, I think Judge Newman saw the problem. We talk about creep. Look how this single common inventor creep can really create havoc. And I would love to see a case come before the courts so they finally have to deal with this and think, oh, this single common inventor was a bad idea. Let's get rid of that. So you talk about obviousness type double patenting, and there are reference claims, and then those are used against target claims, right? So does the reference claim anticipate or render obvious the target claim? Well, look at some of the law we have. I'll give you an example. It's the anticipation type double patenting that can be most troubling, where a species claim can blow up a genus. Another example is, for obviousness type double patenting purposes, a method claim that recites the use of a composition to treat a disease anticipates a claim to the composition itself, right? So let's play that out with single common inventor and these unintended consequences. Let's say a company comes out with drug A, right? And inventor 1 is on it. Came out with the composition of drug A. Inventor 1 leaves the company. A few years later, inventor 1 is working for company B, and they file a patent application, and inventor 1 is on it, and it's to a method of treating a disease that no one knew could be treated with this drug. The disease might not have even been known, right? Now there's a method claim with that inventor 1 on it, owned by another company, a method of treating this disease using compound A. Guess what? That claim with the single common inventor is a reference patent that anticipates the composition claim owned by company A, and there's no way to fix it. No terminal disclaimer can be filed. The ownership is not identical. To me, that's absurd. Like that, something like that would illustrate, hey, I think maybe we got it wrong when we said single common inventor was a problem.
I almost don't know what to ask, because I think the doctrine is just stupid, and I don't think anybody really fully understands it. I mean, in the cases that I read, this, because then we're not even going to scratch the surface on the one-way test versus the two-way test and all that other BS, right? And I know for sure none of the judges get it, and I'm pretty sure none of the participants get it either, because when you look at these cases, it's always stipulated whether the one-way test or the two-way test applies. I mean, how can you have a doctrine that is so complicated that the judges can't understand it? They're all too eager to adopt stipulations about the very test that they're going to review. I mean, this whole thing is just strikes me as ludicrous, really. And so I don't know what to ask, other than maybe now would be a good time, before we lose time and get too agitated about this, to talk about the implications this has on PTA and PTE and what that means.
So, I'll just briefly touch on that. Again, dealing with ODP rejections during prosecution, I find that to be a nuisance. What terrifies me is the ODP problem that gets created from prosecution to an existing patent, right? I call it the landmine. It's another patent that issues, and there's a claim in there or somewhere in the family that's a reference claim that can blow up for anticipation every valuable claim that you have in your first initial patent that never got a double patenting rejection. It was the only application around at the time. And that's just one of the sort of gotcha scenarios that come out of Gilead that I think, when I ask for a lifesaver from the law, I want something that will help out with this problem that sort of got created after the fact. So we'll put up the slide, and here's a scenario that's not atypical, right? Let's say there are 2 patents in a family, and they're in a portfolio that covers a marketed drug that was eligible for PTE on the patent. So patent 1 has a 20-year term, and we'll say 1 year of PTA. And then on top of that is 5 years of patent term extension. Patent 2 in the same family, which now with the change in law in 2014 becomes a viable reference patent to be used against patent 1, doesn't have 1 year of PTA. What that means is, and this sort of baffles me, like if you follow this logic, patent 1 issued as a patent, 20-year term, the patent office took a year too long to get it done, so they got 1 year of PTA. Somehow when patent 2 issued, the day that issued, that 1 year in patent 1 became an unjustified extension of time. How did that happen? How does the second patent make the PTA unjustified in the first? But that's where the law is right now. And the troubling thing here is that unless action is taken before the black line is reaching an end in patent 2, there's no way to rescue the claims in patent 1. Right? There are a lot of cases, and people talk about how PTE is immunized against obviousness type double patenting. Yeah, the PTE period is, right? That's not a factor in the extension of time. But if you look at this common example, there are many patents out there where there's a reference claim, and if that reference claim expires and you're not going to give up your 1 year of PTA, or maybe it's too late for you after the law changed, yeah, you get to keep your 5 years of PTE, but guess what? Your claims aren't valid. So it's effectively 0 PTE years, and there's nothing you can do about it. That to me is most troubling when I see situations like this, or when I see somebody recognizes that they have a problem, a double patenting problem, and they want to get rid of one of the patents, right? We can't. The courts have not put forward a path to get rid of it, and it's very unclear as to how you might do that. And Sherry mentioned how the USPTO was sort of flip-flopping on a terminal disclaimer can't overcome ODP, and then a terminal disclaimer can. I'm just going to give a couple examples of cases from PTAB that are not too long ago. One of them involved, it's called Ex parte Dunkley, and it was actually Novartis, and claims were being rejected over an issued patent. So this was during prosecution, claims were being rejected. And the applicant was trying to say, you know what, that the claim in the other patent, that was an error. That it's not supported by the spec. It never should have issued. We made a mistake by pursuing it. Patent office, you made a mistake by issuing it. We're reissuing it, right? We're going to get rid of that one. Can we have our claim now? The examiner said, no. When you reissue, you don't surrender the initial patent until the reissue is done. So that one's still alive. I'm going to continue to levy this double patenting rejection. So then the applicant said, all right, I will disclaim it, a statutory disclaimer. Be gone, claim 1, right? The examiner said, no, that's not going to work. So they appealed to PTAB. And it's funny when you read the brief because they try to say, like, look, here's this claim. Like, we just want to get rid of this other patent. We tried to say it's not supported, we can't enforce it. We tried to reissue, we statutorily disclaimed it. We would climb to the top of a mountain and shout if it would help. That's in the brief. And actually, with those convincing facts, PTAB said, yeah, get rid of that. That's not a reference patent for double patenting. That was 2018. 2 years later, another case, Ex parte Elbert Harris. Sort of the same situation. Elbert Harris is trying to get claims, and they're being rejected over an issued patent. But that issued patent went through one of those old school inter partes re-exams and had every claim canceled. There were no claims left in that patent. The examiner was still using those claims as reference claims to reject the claims that Elbert Harris was trying to get. He said, you can't do that. He appealed to PTAB, and PTAB affirmed He said, yes, you can. You can use those claims. I call them ghost claims, right? Because they don't exist anymore. But PTAB affirmed.
What
And
was their rationale?
they cited cases like In re Fischel, a pre-GATT case that said, of course you can't cancel claims and then get a new patent that's going to last 17 years, right? It made sense for pre-GATT. It doesn't make sense now.
Well,
right?
it makes sense, maybe even like if you're the one that's making the decision. I don't know any patent owners that go into IPR and say, I want to lose this, let me lose this, I want to come out with no claims. We go into re-examination. The goal is not to come out with no claims, the goal is to come out with something. Right? I mean, so you as a patent owner are saying, no, I give up. I capitulate. I'll walk away, I'll lick my wounds, and that somehow the claim still exists? I mean,
Yeah.
That's a fundamental misunderstanding of the law, is what that is.
What I want to see is a reissue where they actually finish the reissue and get new claims, right? Then what are you allowed to use? The claims that came to be on the reissue and the original claims,
Well,
the
what
ghost
if-
claims? That makes no sense.
Thinking, spitballing this out loud, what if you as a patent owner filed a re-examination,
Mm-hmm.
and then can you fast track a re-examination? I think you can.
It's
Track one?
automatically fast-tracked.
Yeah.
It's automatically, okay, well, yeah, which is ironic that they consider that fast. But save that
It's
for another day.
relative.
Okay, so if you got into re-examination as the patent owner requests a re-examination, could you then cancel all the claims and have the patent issue with no claims? I mean, that would be another test case, right? I mean, because now the claims are gone. I mean, by definition, the patent, and we know that for sure because we have cases where a patent comes out of re-examination. The patent is not gone. The patent is there, but the claims are all gone, so there's no enforceability.
Right. And there's some old cases that say, well, they enjoyed some patent terms, so no good. But again, I don't know how applicable that is. If it's not patent term, that's sort of an unjustified extension of what we
And
otherwise
as was
might get.
mentioned, they make you file the terminal disclaimer. Like, they don't let you kick the can down the road. They're going to make you do it before all this.
Yeah,
Which is
yeah.
wrong. I mean,
Yeah, and
you
maybe we
can't
should just
possibly
get back
do-
to the basics and say, what does our statute say?
Oh,
what,
don't be
how about
silly.
that?
Don't be silly.
What does our statute say
Have you
about
been paying
103?
attention the last 2 days?
Okay.
Nobody reads the statute.
Yeah. So what is the legal way to go forward when you have these situations? If it's something that comes out of a patent application is filed on the same day, let's say if a parent big application, you file lots of cons and things, they can't be used against each other under 103 because they're not prior art. They're filed on the same day. You have to be filed the day before. It has to be in existence the day before to be prior art. So anything that's on that day should not be prior art, right? So anything coming out of a certain patent application, even if it's a broad family, all these things, that should be no prior art. It should just go out. Then if it's between the time when you file, and let's say you file you have a second case before, if you file a case before the first case publishes, and you're the same assignee, then that shouldn't be held against you either because it's non-published, it's non-published prior art, right? And we've got the 103C now. That's not prior art. So that shouldn't be used against you. The only thing that should be used against you is after your first case publishes. And then after your first case publishes, that's fair game. That's just straight obviousness.
Right.
Okay, straight obviousness. So our statutes work fine to solve this issue according to a conventional interpretation of prior art, and according to 103C, which is in the statute, and then you're stuck with it. After it's published, then you have to be non-obvious over what was published. Why is that not the answer? And we're all going, we're jumping through hula hoops here and trying to figure out. And the reason that it goes back to the whole reason why is because there is no statute on what we're talking about. If the MPE can come up with anything they want, the courts can come up with anything they want, there are no guardrails, you're not following the law, and here we are like little lemmings running around trying to answer questions and figure out, oh, boy, how do you solve this? Boy, how do you solve this? It's because it's all crazy.
Yeah. So
Because it's crazy.
Charlie's at the mic. Just make sure the mic is turned on. I think it is. Okay, go ahead.
Right. I'm curious what Sherry in particular would say to the the possible point at least that a question that one, if you look at section 121, that is, that there's a reasonable, that there was language in there that was added in the 52 Act that I don't know if it has any purpose but to address double patenting and recognizing that if you have a restriction requirement, at that point, you aren't going to face a problem. However, the implication would be, one could argue that Congress recognized that absent a restriction requirement, that double patenting is potentially fair game. And separately, while I'm interested in the constitutional argument, I would be curious what you would say to the fact that is noted in the Select, you can trace double patenting back to like the Amesbury Nail Factory case in 1819 from Justice Story, who notably, wrote the first treatise on the Constitution. So I'm interested to see how that goes.
Sure. Right, so with regard to your first question, which is, I think, restriction requirement practice.
In 121.
Right, 121 restriction requirement practice. That's statutory, right? That's the way it's supposed to work. It's statutory, and so if you get a restriction requirement, then you don't have to do anything about that. But that doesn't mean that the contrary is true. They didn't write that into the statute. If Congress wants it there, they need to write that. They need to write obviousness type double patenting in and terminal disclaimers into the statute. Now, there may be some discussion on the Hill now that, there's been some discussion raised about this, that maybe they do want to write that in and they know it's not there. But it isn't there now. The fact that they talk about terminal disclaimers doesn't mean that the rest of everything we're hearing about and all these nightmares were somehow statutorily authorized. And then your second question is what again? I forgot.
Justice Story.
Is what? That's judicial case law, right?
It is.
It's judicial case law. I can go back. It doesn't matter. You know what? We can trump judicial case law with, guess what? The Constitution. Constitution came out before that. Constitution said that Congress is the only entity that can make patent law, not Story. I guess that's my answer to that one.
It's an interesting doctrine in that it doesn't seem to have a lot of thought that has gone into it. I mean, the fact that you can file a terminal disclaimer when there's a common owner, because you have to link these together, and you can't when there's a common inventor. Well, I mean, that in and of itself should make somebody scratch their head and say, well, we probably don't have this exactly right. I mean, and it seems to me that a bunch of engineers and scientists ought to innately understand that, right? That you run tests in labs, and I got a great result over here. Let me run it and see if under different atmospheric pressures and temperatures I get the same result. And if you don't, and that wasn't what you expected, it's like, okay, well now there's something going on behind the scenes I don't really get, and makes you question whether the rule there or your thesis is proper. But there's never seems to be a question about whether the thesis is proper. And with double patenting, this isn't squarely but you can't use to pick up. You can't use one patent against another when a restriction has occurred, right? Well, there's a case, I can't remember the name of the case, from now about probably 10 years ago, where it was happening because it was the grandparent was being used against the great-grandchild, and the Federal Circuit said, well, that rule only applies at the first level. And I think it may have been a Pfizer case, and don't quote me on that, but it was, and the patent owner, patent applicant, had just, every time a restriction had been made, had acquiesced with it. And they were internally inconsistent, because there were different examiners over the course of the life of the patent in the pharmaceutical area. So rather than fight it because you can't use one against the other, they just kept restricting, agreeing, and then finally an examiner picks it up and says, well, I'm going to use this one against that one. And because an intermediary restriction was contradicting the previous restrictions, but the patent office would never have given any oxygen to that. They never would have. You know how often, I'll let you see how good you are at this, because I know the answer. Do you know how often the office overturns an examiner on a restriction?
I'm guessing it's low.
I would say, yeah.
Certainly less than 10%.
Yeah,
1 in about every 10,000 requests.
yeah.
Yeah.
All right, I'm
Because
right.
I was at a
More
retirement
money.
party for one of the old directors of OPLA, and I made the comment that, it's just foolish to challenge a restriction requirement. And you never overturn them. And he said, "Nah, I wouldn't say never." And I said, "Really? Really? Well, what's the number?" And he thought very pensively for a minute. He said, "I'd say probably we overturn 1 every 10,000 requests." And I looked at him and I started laughing. And I said, "That asymptotically approaches 0." So even if you do object and say, "Hey, office, this is inconsistent. You can't do this one here." There's no oxygen given to that. I mean, you're cuckoo for Cocoa Puffs if you're challenging it. It's just wasting client money to challenge that.
Well, and just like with the second basis for, you don't want somebody to be sued by multiple assignees. Well, when there's only one common inventor, well, if there's no common inventor, they're going to be sued by multiple assignees, right? So if there's one inventor in common, then suddenly now you can't get a patent and you can't cure it in any
Right.
way because
Yeah.
you can't do a terminal
And
disclaimer.
let me just say, it wasn't a director of OPLA. I remember now, it was the director of the Office of Petitions. So he was the one who actually had.
He's the one, he knew.
Saw these petitions, so he would be in a position to know definitively how often this happens. And it's just ridiculous. And now, and I said cuckoo for Cocoa Puffs if you challenge us. Don't take that as literal, because now in the face of everything that's going on, you have to challenge. Right? Because you can't acquiesce, because maybe later on when you say, well, I didn't agree with this, I pointed it out, the office did what they wanted to anyway.
Yeah.
Maybe that's some kind of defense in this crazy Alice in Wonderland, Willy Wonka world we live in with chocolate and obviousness.
And it seems like the double patent rejections are getting more aggressive.
Oh, yeah.
They've gotten more aggressive in the past year, and I wouldn't be surprised if that wasn't because of this USPTO FDA initiative, and they're thinking about how to, cut out patent term. And
I think
we're seeing a lot more.
All of this
A
goes
lot more.
to that one point, right? They're trying to take away patent rights. They don't want them to last as long.
Mm-hmm.
They want them to go into the public domain quicker. And I think it's all about drugs. It's all about generics. Got to get generics to the market quicker. Forget for a minute, there's all kinds of drugs that are off patent for which there are no generics on the marketplace because there's no money to be made. It's not like a panacea. When the patent ends, you're going to have, unicorns and leprechauns coming, or leprechauns riding unicorns.
We as an industry don't do a very good job of advocating for ourselves. We just lay down, take these terminal disclaimers, complain about them, and keep going. We really do a terrible job of representing, what we're saying in this room. And we do have a horse to ride, which is in Cellect, which is going up, and we should at least give that a little bit of airtime, because I guess it's going up for en banc soon, and then I would give the odds of that fairly low, but they're trying, and then my guess it would go up to the Supreme Court. And we as an industry have to make all these statements known. We can't be quiet. If we're quiet, nothing will happen.
See, I want to predict that
It might
there's
get
no way
worse.
the Supreme Court takes this case because double patenting is just too complicated. But I'm not sure that they'll understand that. And I would say, well, it doesn't affect enough people for the Supreme Court to. But they take the damnedest cases. They took the Kimball case, and that affected almost nobody. And then they said, yeah, it's the wrong rule, but we're going to stick with it because it's been the wrong rule for 50 years. Well, it was the right rule for patent eligibility for 35 years, and you changed that. I mean, I have no confidence.
Yeah,
And
one of the big problems with PTA in general, when we look at this ODP kind of scenario, is we keep in mind really what that means. It means the patent office didn't do their job. Right? That's really what it comes down to. So you're letting the patent office write the rules, write the policies, and write the disclaimers and how this stuff is going to be applied. Well, of course they are. They're cleaning up their own mess. And then the courts, they're kind of blindly just applying this, saying, well, we have this body of case law that we worked on pre-GATT and let's just continue to apply it. Like there was a little hope when we had Breckenridge and Ezra that was like, hey, well, you can't cut this off when it's a statutorily extended rule. And we got excited because we said, hey, Mitsubishi Tanabe is better than Ezra. All right, never mind. But it was an opportunity for us to look at it and say, hey, no, they got it right. They reversed what Magna did back in 2015 or whatever it was. But now here we are in Select, and the justifications, even when they try to parse and say, well, look at the scheme in 154 and 156, they're different. So it means they must have assumed. See, the word disclaimer appears in 154. It has to be terminal disclaimer. Well, that's absolutely wrong, right? The disclaimer could seriously be 253, right? It could be a 253 disclaimer. That's exactly what they meant.
Exactly.
Why do we know that's what they meant? First of all, read the congressional history. It's not, as you already mentioned.
Yeah, it's not there.
There's nothing there.
There's nothing there.
But then when you look at 154B and then you look at 154C, internal to the same section, the word terminal disclaimer appears in 154C. 154B that they use to cite to doesn't. It just says has been disclaimed. So they intended something to be different. If they didn't, this stuff isn't new. They could have put it in 1952. They could have put it in 1994. They could have put it in 2011. Congress never did, and therefore this whole argument of congressional intent and statutory construction is just bankrupt. There's just no justification for it.
They clearly knew about obviousness type double patenting. They knew about terminal disclaimers. They did not write that into the PTA. They used the word disclaimer.
So we're almost at the end of our time, and we haven't said that obviousness type double patenting is unconstitutional.
Okay, one more time. What is that?
Okay,
What are
for
we
a
at?
while.
Does that count?
What are we at?
So you
80?
wanted-
We have to get to 10.
Well,
Does
if
somebody
you-
want to raise their
that was
hand
my-
and say
I'll
it? We got to
count
get to 10.
Mine is 9. Do you want to say it one more time,
That's your
Cheryl?
final
Oh,
words,
yeah, I
Sherry.
have to.
Your final
Okay.
thought.
It's very cathartic, actually.
Well, say it.
Cathartic.
No, not that word.
No.
Say the other thing.
Okay. The non-statutory, judicially created doctrine of obviousness type double patenting is unconstitutional.
Okay. All right, so we know what Sherry's final thought is. We know
I think
what
I just gave mine.
Her initial thought. That was your final thought?
I'll take that as mine.
Okay, great. Rob.
That's
do you-
11, by the way, because he took mine.
Oh, so he agreed
I
with
get
you?
an 11
So
for
we're
that.
11? Okay,
Yeah.
we're at 11. All right, so
Okay.
Rob, do you want to give your final thought?
Unconstitutional or not, it's here now, right? So we've had to
Right.
live with this and been trying to navigate the murky waters of safe harbor and doing the best we can to get the right restrictions, file dibs, maintain consonants, shield patents from each other within a family. So we're doing the best we can. The problem I still have, though, is with the gotcha ones, where the law changed and the problem's already there, and it's too late to do anything about it, and there's no help to try to kill the patent causing a problem.
But do you think that now has become a feature, not a glitch? And I say that because I think so much of this, and I've said this over the last 2 days now, so many of the problems we've identified all are based on the purposeful intent to get patents to go into the public domain quicker, to have more narrow coverage, to do away with continuations, divisionals, and even the number of claims. But they,
There seems to be a sentiment driving that from somewhere. And just on a final note, as scary as this Select scenario is with the law that we just got, where I'm looking at patent families where, again, one of them has PTA and then PTE. Under Select, they say, no, you have to count the PTA. It's an unjustified extension. There's another round of Select cases, and I think someone in this room is familiar with them, where the Central Re-Exam Unit just said patents expiring the same day are good references to use against each other, valid references. So that one may be bubbling up. And again, it's going to cause the same sort of threat here, just without the red line.
I don't get that. I mean, maybe I just fundamentally don't know what prior art is anymore. I think that's the
Brent's
problem.
got a question.
Go ahead.
Okay, for just practical application, I mean, so what do? The day before you go into PTE, do you just file a bunch of terminal disclaimers over every single patent potentially out there? I mean, you can still terminally disclaim. I get the PTA issue. That boat sailed. We're stuck with it.
Yeah.
There's probably a lot of patents out there now that are invalid, post hoc looking back. But,
Mhm.
I mean, what's the solution for us out here, in your view, outside of protesting and arguing? I think that as well. But what
yeah.
do you do?
You know,
Just-
in
So the question is, what do you do? We have to live in this world, so what do you do on the client's behalf?
Right. In some circumstances, if we catch an issue at the right time, we can trade some of the PTA for PTE, whatnot. That's not typical. A lot of times, file a TD and eat the PTA if all your
Yeah.
claims are vulnerable. And if you have some time, if your reference patents aren't about to expire for a while, then maybe, wait and see, but dock it and make sure you do something before the reference patents expire. Don't let them expire for other reasons. We don't know if paying a maintenance fee would cause a problem. Another unknown, not a big issue for pharma, because we're usually looking prospectively. We want to keep a generic from coming on the market, but the damages issue is an unsettled question of law, right? So even people who don't care about term, if they have one of these problems where one patent has a little bit of PTA, 5 days, another one doesn't, they want to sue someone on the patent with PTA, the claims are alleged to be invalid, they file a terminal disclaimer. It's an open question of law, at least before the Federal Circuit, whether or not they're entitled to damages for the period of time before they filed the terminal disclaimer. Right? So unwittingly, that's a fight people may have to fight.
And in the abstract of 1 or 2 patents, some of that makes sense, right? The problem is when we start looking at the subjective nature of the assessment of obviousness on a double patenting scenario, and when you have multiple members of a family or related applications, like a composition and a method, right? That's where we really start running into the difficult questions that I think Brent's bringing up.
Yeah.
Vince, I think you have a question over here.
Yeah, I'm just curious, is the strategy going forward to put all patently indistinct claims in one case? So that's another way they're saying less cons, because you have a concern that if the first one goes out with a lot of PTA,
Mhm.
then you can't afford a con that comes out later that has no PTA, that has a patently indistinct claim. So is the strategy of now you basically got to put all the patently indistinct claims in one case and have to fight
So-
until the end?
So the question is, should you
Define
put all
patently
patently
indistinct.
indistinct claims in the same patent?
In the abstract, yeah, that might be a good goal, or if you have to reissue to try to do that. But in some scenarios, it's problematic. So think about patent term extension, right? A patent can only be extended once for that. And let's say you have a new construct of a therapeutic, and then you're going to also disclose specific species, which are going to be separate drugs to use to treat different diseases. And they're in there supporting the broader construct genus claim. Now, if you want to have patent term extension on both of those for the regulatory review period that it took for both of those, you can't do it if they're in the same patent, right? You have to split them up into second patents. And the second you do that, if it's a composition claim versus a composition claim and there's no restriction, you're going to blow up the genus claim in the first one. So ideally, yeah, if you can do it, but sometimes it's not the best option.
Okay, and Doreen, your final thought.
I would like to see Select go all the way up and see what happens, or I would like to see what the court mentioned in Breckenridge for a reason, go back to issue dates. Let's stop looking at expiration dates and go back to issue dates, because when you're saying that a later issued patent or can somehow be prior art to the earlier issued patent because of expiration dates, it's impossible to game that. It's impossible. I can file terminal disclaimers, but now I have to predict where I'm going to file terminal disclaimers and file them prospectively, or I probably have some filed in cases now that I didn't need to file, but I should have filed them in other cases because of the change in law. So if we went back to issue dates, that would be my dream.
Yeah. Patent term adjustment is not gamesmanship. That's patent office delay.
Right.
There's an awful lot of mischief that has happened over the last 10, 15, 20 years. I don't know that it was all intentional, but as it started gaining steam, I think it's become intentional. Like the publication of patents that turned out to be away. Nobody cares now whether the patent office takes their time. Take your time, take as much time as you need, patent office. We already have the benefit of the disclosure. Switching from 17 to 20 years, that seemed like, it's no big deal. It is a big deal. It changes things. It makes things more complicated. And then when you get into PTA and PTE, it's like, we're extending your monopoly. We're just going to decide not to do that anymore. You know, I mean, so it's like a cascading effect of unfortunate decisions that were made that are being used against the patent owner. Nothing ever seems anymore to go in the patent owner's favor. And this pendulum that we keep talking about, I'm afraid the ball has detached from the pendulum. And it's just, you know, off in space where there's no friction, and it's going to go forever until it's acted on by a force out there somewhere in a different solar system. But that was a fascinating, if not scary, conversation. So thank you all. I appreciate it.